Next up, we have the member status workgroup report and first read on proposed bylaw amendments. So at this time, we'll be calling upon Chair Kari Petrasic and Chief Regulatory Counsel Hinata Garcia.
We sharing this. Hello. Okay, let me get set up. Okay. If you could take a look at page 135 of your materials, that's where we start our presentation. So we are here to share a little bit about the member status work group and the work of this group. And the presentation is going to be about the findings and the final recommendations for first read today. So for the agenda, what we are going to do is just give you a little bit of background, the creation of the work group, probably, go over the current license status options so people understand what we currently have in place and then why we are changing or what recommending to change. We'll go over the member feedback received, our research into other jurisdictions, and finally, the first read of the recommendations. So I'm pretty confident that everyone here at some point has heard from a member who is retiring from the practice of law and reached out to you, potentially surprised that there is no such thing in Washington called a retired status, and maybe even, disappointed that they would have to choose voluntarily resigned instead of retired as their final status with the Bar Association. As one member puts it, voluntarily resigned sounds like you are surrendering your license just in the nick of time before the feds broke down your door and locked you up. So it's not a term that, people feel that really dignifies a long career and, all they have done for the contributed for the profession. So based on all this feedback, well, I guess we'll go over. Okay. Okay. So here's a slide that shows the current license status options. So we have the active license status, which allows, the person to practice law, volunteer, serve on the BOG, and take advantage of all of the member benefits that we have to offer. The pro bono license status allows practice, but only, it's a limited, right? Limited to volunteering for a qualified legal service provider. Inactive are for those who are not practicing, at least not in Washington, and they pay a $200 license fee, and they are able to return to active after confirming, meeting certain requirements to return to active status. The requirements change depending on how long they're inactive, and that's something we discussed at the last meeting with the MCLE requirements. We also have honorary status, which is essentially the same as inactive, but there is no fee associated with it. And only members who have 50 years of active or judicial status qualify for honorary status. We also have judicial status, which is for members who hold a judicial office position, right? And currently it's not available for pro tem judges. And then finally, we have voluntarily resigned, which is essentially for those who are no longer a member of the Bar Association. So people who are resigning and who are retiring and don't qualify for honorary are likely to choose voluntarily resigned, or maybe continue to be involved in a member in a limited capacity and be inactive, or if they want to continue to volunteer with the Bar Association and be able to provide legal advice, they could still obviously pay the active license fee and remain active. So it's kind of hard to see here, but this chart is just a summary of all the license status and the benefits that come with each, as well as the eligibility requirement and the license fee associated for each status. So in order to address some of the concerns we have heard from members over the years, the Board of Governors decided to create a work group to evaluate license status options currently available to WISBA members who are leaving the profession and to propose revisions to the current license status options. So with that, I'm going to turn it over to Kari, who is the chair of the work group.
All right, so this work group was created per the charter with the intent to get feedback from all the interested parties and groups who may have an interest or stake in the changes that we'd be making. So obviously with this comes a potential financial implication. And so obviously our treasurer was part of that. We had a member from the senior lawyers section, and he's a past president as well, Steve Crossland. We had an active member, a pro bono member, an at-large member, and then our BOG liaison was Governor Ahern. So we were well represented across all people and statuses. So this work group started by looking at what other states were doing, other mandatory bars specifically. And we looked at 32 different jurisdictions, and all in all, pretty much every jurisdiction we looked at had some kind of similar structure with different statuses. No jurisdiction had the exact same thing as we do, but we got the general sense that yes, other jurisdictions have similar statuses related to active, inactive, pro bono, and resigned or retired. And so in light of the variety, then we basically looked at what would be the best benefit for our membership. Hopefully a lot of you received the survey, and based on the amazing number of responses we got, this is quite an impressive number based on what staff has told myself and the work group, to get over 800 responses to the survey. We were able to basically compile the answers, and there were just a few basic ideas that people had that could be lumped into a couple thoughts and ideas that we focused our discussions on. So the first main question was, are you aware of the different license status options available to members? Well, most people said yes, but there are still around 15% that said no. So that's definitely something that the bar staff has said that they're definitely going to try to reach out to enlighten people on the different license types that there are. But for the most part, people know what the options are. When asked if those options meet your needs, the majority of people said no. When asked what's missing from the current license status, we received 550 comments from those 805 responses. And of the comments received, 44% wanted a retired option. They did not want voluntarily resigned. 20% of them, if they're retired, they want to be able to volunteer and provide pro bono services and even give advice to family and friends. And then another 9% of the comments said that they wanted some option just to be able to do some kind of part-time practice. So those are a lot of people who are maybe like in firms of counsel positions, or other, if you're a solo or small firm attorney, you're just working part-time as you're sunsetting your practice. Some of the other comments that we got, there were a lot of comments talking about the inactive status being too expensive or restrictive. If you're inactive, you can't practice, you can't even volunteer on a board, committee, task force, work group, anything like that. Can't volunteer. There were also some comments about your eligibility for honorary status being too restrictive or exclusive. And there were also some comments about the pro bono status being too narrow or expensive. And so here are just some comments that were given from various people. In particular, one person said inactive just sounds lazy. So definitely there were some stronger feelings about this particular topic and what statuses should be considered. There were a number of options that the work group looked at, and the ones that we rejected and did not think would be appropriate for us to do for a variety of reasons includes the suggestion to allow retired members to give legal advice to family and friends. The work group rejected that because of public protection grounds. Also, the work group believes maintaining license requirements, including CLE and client protection fund assessments, are required to practice law. Another option that we rejected was reducing license fees for senior members, because that would have considerable financial impact on our bar association. And another rejection was changes in honorary status, eligibility, and the creation of a hardship license fee reduction would provide financial support and recognition of a long career in the law. So the recommendations that we are recommending that hopefully will be approved by the Board of Governors, not today, but at our next meeting, after we get comment and feedback, is to give members the option to have their voluntary resignation displayed in the WSBA legal directory as either voluntarily resigned or retired, to decrease the number of years on active or judicial status, to qualify for either honorary or emeritus status from 50 to 40. And right now it is called honorary status, but several comments have been made to us, particularly by the senior lawyer section, saying that emeritus would be more appropriate than honorary, especially if you look at the actual dictionary definition of both of those words. And so changing it to emeritus is something that we are considering. Allowing members to include years licensed as active or judicial from other jurisdictions to count towards the 40 years required for honorary or emeritus status. To allow inactive and honorary emeritus members to volunteer on WSBA committees, boards, panels, councils, and task forces. To allow members who are age 65 or above, or who have been licensed for 40 years or more in any U.S. jurisdiction, to be on judicial status for pro tem judicial positions, and provide a hardship reduction of active license fees for members who are 65 or older, or who have been licensed for 40 years or more in any U.S. jurisdiction and have a gross annual household income equal or less than 400% of the federal poverty level. This chart basically summarizes everything that I just said and shows all the different statuses of what we're proposing. In red, it shows what the changes are. So under people with an active license, the change would be adding the ability for people 65 and older or 40 years in practice to request a hardship reduction. For pro bono licensed people, they would be able to serve on our committees, boards, task forces, and councils. The judicial license fee type, people that are 65 and older or 40 years in practice, if they pro tem on a regular basis, would then be able to claim a judicial status. Inactive members would be able to serve on WISBA committees, boards, panels, councils, and task forces, as would honorary or emeritus people. They too would be able to serve on committees, boards, panels, councils, and task forces, and the eligibility would be 40 plus years in practice. The work group thought it was really important to allow the pro bono, inactive, and honorary or emeritus people to be able to volunteer on sections, boards, and committees because, one, us as a board of governors, we keep talking about the importance of getting more people engaged in the work that we do and becoming involved. And the feedback that we got from people in these categories also expressed an interest of wanting to be involved, and especially the comments for inactive people thinking it's too expensive, paying $200 to do nothing. This is a way that, the bar is not going to charge anything less than $200, but if they had the opportunity to feel engaged and active in the bar association, their feelings might not be feeling like it's too expensive to be a member for $200. So the fiscal impact for these recommendations is that, it depends on which category we're talking about. So changing your status from voluntarily resigned to retired, there's no fiscal impact on that. That's just the change that goes on the legal directory. Allowing volunteering by inactive and honorary or emeritus member, there would probably be a nominal financial impact, potentially around $2,580 to change or to allow pro tem judicial status for senior lawyers, potentially around the financial impact around $5,300. Changing the honorary or emeritus status from 50 to 40 years would be around $85,400 in the first year and an additional $6,000 thereafter. An active license fee hardship reduction would be approximately $8,256 a year. And including the number of years licensed in other jurisdictions in this, it was determined it would be very hard to estimate the financial impact, but most likely it would be very small. So the estimated total fiscal impact of the recommendations would be $101,540 in the first year of implementation and $107,540 per year after that. And again, the work group, we all voted and unanimously approved these recommendations that have been brought before you today. So, any questions, reactions, feedback?
Just one little thing that I noticed there, the 40 years in the patent world. I'm a patent attorney.
Can you talk up a little more?
In the patent world, I'm a patent attorney, and we either hire PhDs or we hire engineers like myself who spent 10 years in practice as an engineer. And so we hit the legal career around 30. So I will retire with 35 years and not 40. So if I had to, maybe I understand 40 is a number that fits most people, but it's a good example that would exclude all patent attorneys here.
Thank you for the feedback. We did look at changing it to even as low as 30 years and 35. And we felt that and recognized that there are people, not just like patent attorneys, but there are other people who come into their legal career later in life. I had a good friend I went to law school with who was 50 when she was in law school and, would never even probably hit 35 years or even 30. But a lot of it too had to do with the fiscal impact. If we were to lower it to even 35 years, the fiscal impact was going to be exponentially higher. in terms of much higher than $101,000.
Governor Fay.
Thank you, Madam President. There is one little nit here I'd like to bring to your attention. It says here that in order to include the time you've served in other jurisdictions, you would have to pony up a certificate or other good standing from your prior state. That is a problem. I know that's a problem because I was disbarred from New York. I got notice of being disbarred for not paying my bar dues. I called up my friend who's on the board and I said, Kathy, why am I being disbarred? I left New York in 1988. The courthouse burned down with all the records. So if I wanted to get a certificate saying that I was in practice in New York from 85 to 88, I could not do that. They don't have the records. Now, WSBA has my application that showed I was active in New York from 85 to 88. So, golly, I would recommend we look at our own records and not create a problem for people who just want to be an honorary member.
The idea is to create a uniform mechanism that people can demonstrate that they meet the criteria, right? Based adding the membership in another jurisdiction. So for us, it's just a matter of being able to verify the information. So maybe a formal certificate might not be enough, but potentially a letter. We could probably come up with a different way of demonstrating, right? And status certificate or just proof of membership and in good standing. It's also something that's part of other regulatory processes. So it's not unique. It wouldn't be unique to this bylaw amendment. So there could, so long as we could have, a formal way of verifying the information.
There is no formal way to show I was a practitioner in New York City 30 years ago. The state of New York has lost. They know I resigned in 88, but they don't know. Well, they know I resigned in 96. I had to make a declaration. I had to formally resign.
Yeah.
And they waived the back bar fees.
Yeah, potentially could be a declaration, but we haven't thought about the details of that yet. So I appreciate the input.
Next, we have, I think, Steve Crossland on the line. Steve?
Yeah, good afternoon. How are you? First of all, I want to really thank Amata and Kari for leading us through that process. It was a pleasure and honor to be a part of that work group. And I, as you saw from the report that I represented the senior law section, and happy to report they are unanimously in support of this, and particular emphasis on reducing despite Kevin, your others' view of reducing it to less than 40, they thought reducing the bar from 50 years to 40 years was appropriate. They also very strongly felt that changing honorary to emeritus was an important thing. Just as was mentioned, it fits the definition more importantly, but just the ring to them felt better. The other thing that I think was important, and I think it's really notable, is they felt very strongly about being involved in bar activities. And so being involved in committee work sections was important to them. But happy to report from all of them that they're in support of this proposal. Thank you.
Thank you, Steve. Governor Ahern.
I have two questions and a comment. First question, I strongly support the emeritus thing, but my question is, when is the decision going to be made on whether it's honorary or emeritus?
So the work group is going to meet again on the 25th. You should have since you're the BOG liaison, you should have received a calendar invite. So we will be discussing it at that meeting. And then it'll be brought back for a second read and hopefully approval at our next meeting. So.
Okay. Second, if you can just briefly just explain, what's the purpose of having the separate pro bono status?
Separate from?
Just like the status, the regular status is a license
instead of active. So pro bono status is usually members who are no longer practicing day-to-day, but they want to maintain the ability to volunteer with a qualified legal service provider. So there is a list, some nonprofits who are eligible. And so they provide services under the auspices of that legal service provider. And the benefit is, one, they get to do a great service at a reduced rate. Also, if they do, I believe, 30 hours of volunteer work, I think their license fee is essentially waived. So it's a public service and, honoring the members who are doing this work.
Okay, and then my comment is the one that my next door neighbor, Althea, bit my head off when I mentioned this at one of our committee meetings, and I'm sure she's going to do it again at our next one. But I'm not persuaded that removing the CLE requirement for the pro bono status, I'm not persuaded that's a good idea, because I think all attorneys should have the same legal education, competence, keeping up to date what's going on. And I know that's an issue, but I just wanted to flag that I'm not persuaded. And Althea can yell at me when I get home.
Yeah. So to respond to that, and I'm not sure, I know we discussed this in our work group, but the reason it's not included is because QLSPs provide trainings, and it's a requirement of QLSPs to go through trainings and have their own CLEs and workshops that they do. So the people who are under pro bono and that's all they do, the assumption is they're getting their trainings and CLEs through the QLSPs.
If I can ask a follow-up question then, because I know from the King County Bar Association stuff I've done and WDTL, getting the CLE credits from WSBA is not really, really a hard administrative thing to do. So do the QSPs, if they do the CLEs, why do we, WSBA, give our blessing so those count as CLE hours?
The work group is not making any changes to the recommending any changes to the MCLE requirement, or I guess the not requirement of pro bono members. So that wasn't something that the work group focused on. I think it's a question that would probably, we would want to include the MCLE board and the pro bono council to be part of that if a recommendation is to be made. And we did not include those entities in our discussion.
Next, we have Chief Disciplinary Counsel Doug Ende.
Thank you, President Angel. I have a question. It may be a comment on the use of the term retired in the legal directory in lieu of the term voluntarily resigned, which I understand in concept. And my question or comment relates to implementation, and maybe you haven't talked so much about implementation yet. My thought is it will be important for it to be very clear on the legal directory and clear in the minds of those using the term retired that it means not eligible to practice law. And the reason, or one reason it's important, is because once a member resigns and becomes not a member, we lose regulatory authority over that individual. And the risk I'm thinking about is either if in the mind of a retired former member, or perhaps in the mind of someone who is in need of legal services, we don't want anyone to think retired means I can still do a little bit of this and that. I can still help. I can still provide some legal advice. Because should that happen, and should something go sideways, and something unfortunate happen in the course of that representation, if the individual who thought they were a client contacts the Bar Association and says, can you help me? Can you do something? Our answer in that situation is we have no disciplinary or regulatory authority over that individual. So my question or comment is, I hope it is brought home, both on the directory and in the minds of those who will be using the retired designation, that it is a status that means not eligible to practice law.
Thank you, Doug. That's exactly correct. The recommendation is that retired means retired, and that's something, actually a little phrase that the work group said a few times, retired means retired, you're not practicing. And I say that because there were quite a few comments, about 20% out of the 805 people who responded were seeking a retired plus status, or something that allows them to provide services, give the good advice to family and friends. And what the work group discussed is that no matter who the client is, whether it's a family member or a friend, they're still a client and it's still considered practicing law, right? And the work group decided that anyone practicing law should comply with the requirements to maintain competence, like MCLE, and contribute to the Client Protection Fund, and contribute to the finances of the Bar Association. So that's definitely not what the work group is proposing, and we'll do our best to make that very clear in communicating for our members if that's approved. I also want to highlight that the legal directory currently has a definition of all the statuses, and we're actually internally working on some improvements to that. That's not to say that confusion can happen with any status, because as you saw, we have quite a few, right? And do you think, would a public member fully understand where honorary is versus inactive? And so I think the problem is probably bigger than this, right? And I also want to highlight that for official purposes, so if you take a look at page 149 and you can see the actual language we are proposing for the bylaw amendment, for official purposes, the member status will remain voluntarily resigned. So the backhand official purposes, what we would communicate, it's still voluntarily resigned. The label on the front end for members, for the public, then we are giving the member who is resigning the ability to choose retired. So that's just a label. The actual status is remaining the same. And that's important to us because the courts rely on the information we provide to them. And we do not want to create a status with the same name that means the same thing, right? So we have one status already. So we're just creating a label to address some of the concerns we've heard from members. But we communicate with the Office of the AOC every week. We provide, information on who is eligible to practice, and we would not want to change our approach and create any confusion with the courts. They rely on the information we provide. So short answer, voluntarily resigned is still the status, will be a label in the front, and we'll do our best to communicate that to anyone who chooses to use that label, understands that they are no longer a member and allowed to practice law.
Thank you. Next, Judge Tracy Flood.
Can you hear me?
Yes, we can, Judge.
Thank you. Good afternoon. I wanted to say thank you for providing that report and information. I feel that it is very valuable. And speaking to the pro bono portion and the need in the civil legal aid area, an arena, we have so many individuals that are unrepresented and need assistance that they get through our legal services programs. And I can recall that the Board of Governors taking the time beginning from when I served on the board, moving in the direction of allowing the training to be done by the legal services providers for those individuals that are serving, also covering those individuals as far as insurance and making sure they were trained and skilled in that area. So unlike Governor Tom, I would say that the training that they're receiving to do the work should not raise any concerns as far as CLE requirements. And I am happy to hear the proposal being put forth. Thank you.
Thank you, Judge Flood. And next, Governor-elect Villeneuve.
Thank you. I'm just wondering, General Rule 24 defines the practice of law, and then Section B defines a whole bunch of exceptions to what is not the practice of law around here. And one of them is pro bono qualifications. Other ones are, serving in different roles, mediators and things like that. When I see the retired status and what is trying to be achieved by that, I see a little overlap there. So was that considered as part of, because if the goal is to create a retired section and saying, while you're retired, you're still entitled to do a couple of things. If it is excluded from the practice of law, it says it is still practice of law, but so it allows you to practice this, even if it's. So I just don't know the interplay if Rule 24 was factored.
The citation again, please.
24.
Yeah, what part?
General GR 24 defines the practice of law.
But
and then B is the exception and exclusion. And in there, for example, Section 1 provides for practicing law authorized by a limited license to practice pursuant to admission and practice Rule 3G, which is the pro bono admission system, for example. So it's an exclusion to the practice of law. So if you're doing pro bono and you've left the bar in theory, this is not practice of law. If I read correctly.
Yeah, I think what it's saying is that people practicing law under APR 3G are practicing law, right? Like, so is your question whether we should have put providing services to family and friends as an exception?
No, you're defining the general definition of practice of law. That relates, for example, to the entities that we were talking about earlier. And then B is the exception to that. That allows you to not be considered to be practicing. Maybe I got this wrong.
I think I might provide a little clarification. I've studied GR 24 way too much related to the practice of law board stuff we did. What it's pointing to is the pro bono admission. So it's saying if you have the pro bono license that we talked about, you're allowed to keep that. That's all that rule says. So the retirement is kind of the same concept where of what the pro bono admission is. So that's all that's pointing to is the retirement would be separate from the pro bono status that we already have.
But wouldn't it be easier to amend GR 24?
I think that's where this comes. You have to have these admissions licenses, and this is it. GR 24 points to APR 3, which is where that pro bono status comes in. So this is kind of another version of that, I think, is my understanding.
Other than the pro bono status, every other status is created by the WSBA bylaw. So that's what we are proposing changes to.
Thank you so much, Chair Petrosic and Chief Counsel Garcia. Thank you for that presentation.